Welcome back. Well, most of us hate thinking about what will happen after we're gone, but it's important to make a plan if you want to avoid having the government decide who will get your assets.
True. Alan Spiegel is an attorney with the McLario firm. He's here to share the most common mistakes people make when it comes to estate planning, plus how to avoid them all. Good to see you, Al.
Good morning, ladies.
Great to see you.
I didn't think any of us are going to die. We're going to live forever, right?
That's right. Well, that's plan A. But just in case that doesn't work out, let's talk about plan B.
Plan B.
And that involves not making these big 5 mistakes. And the first one is, of course, not making
Just not having a plan.
Right. Well, and a lot of us kind of make it seem like we're sort of choosing. We'll say things like, I'll just let the kids figure it out.
Ooh.
And that isn't how it works. The kids have to figure it out with the government and the creditors and all these things where we can manage better and really set up the kids for success and to remember us fondly instead of saying, boy, I wish mom and dad would have done a little more work because we wouldn't have had all these headaches.
Yes.
Is it an absolute, if you don't have an estate plan and you don't identify who is to have your assets, the government is involved and it goes to probate?
Yes. Now, there's different types of estate plan. Maybe your estate plan is just putting beneficiaries on an account or something like that. So it doesn't have to be super formal. But it probably has to be more formal than you think it is. So you got to just talk it through and make sure your bases are covered. One of the things I see is people say, oh, don't worry, we have beneficiaries on all our accounts. And I'll say, what about your house? And they'll say, oh, didn't think of that.
Oh, yeah, the house.
So mistake number 2 is that you think, oh, I can just do something online.
Right. And, you know, a lot of people, there's a lot of stuff out there, a lot of, you know, AI stuff, making documents for people.
Yep.
And all those things come with no security that it's going to get done right. And even if they do it right, those things are only going to do what you ask them to do. So if you go in and say, make me a will, it may make you a will. And if you're lucky, it might be a working will. But that will's still going to have to go through the courts, which a lawyer would have told you if you would have met with someone who knew how this process worked.
Plus, I feel like when you meet with someone like you can ask questions. Like you can say, well, I'm not sure if this is a good idea. What's your thought? And based on your experience, your education, all of those things, you get the value of talking it through.
Right. Well, based on me seeing these things go sideways, I can say maybe having your 4 kids as the co-executors isn't the best idea. If they get along, just pick one and not have everyone have to sign, and just different plans that sound good in theory, but when it's real humans with real problems going through them, it can get really messy and not be ideal.
Yeah. Mistake number 3 people can make is failing to plan for disabled beneficiaries.
This is a huge area in estate planning law. We have a lot of people who, not because they're disabled, but because they're receiving benefits from the state, have limitations on what they can receive.
Yes.
So if you have a person you know that's receiving benefits, and those benefits are what's called asset limited, and they get a check from your estate, it's probably going to kick them off those benefits. Whatever you gave them is going to get gobbled up by whatever care they're receiving, and then they'll have to go through the process of reapplying. So all you're giving them is a headache, where we can do a lot of things to protect it in a special needs trust or reallocate it to somebody else that's going to match how you actually want things to look a lot better.
So great. It's smart.
Such important things to think through. The other one is failing to plan for immature beneficiaries. And that idea is like you think about young people, really young people inheriting sometimes hundreds of thousands or millions even.
That's right. Well, the first problem is people that are under 18 legally can't own things. So if you make your grandchild the beneficiary of your bank account and they're 6 years old, the court's got to supervise that until they turn 18. And then even worse, once they turn 18, they just get it. And that's probably not great based on me being 18. It's not, wasn't my wisest time of my life. And then the next phase is from 18 until 25 or 30, whenever people kind of get equipped and have the experience to manage some assets. Let's get them with some older, wiser people who can just be the gatekeeper for a while. We don't restrict them. We just say, you got to ask, uncle whoever or aunt whoever to get permission to do whatever you're thinking about doing.
But here's what happens. You set that plan, you do all the right things, and then in 10, 20 years, aunt or uncle, whoever, has passed on, and they're your person. So your mistake number 5 is failing to update your estate plan.
That's an excellent transition, Tiffany.
Thank you. Because I think about how it's happened in our own family, and a lot of things that you've done change. People pass.
They do.
Mental illness happens, things happen.
Sure, yeah. One of my most notable things that happens in my office is when I go get with a couple who has kids that are 12, 13, in that age, where 12 or 13 years ago, they did their first will, and I say, oh, here's who you have listed as your guardians. And they say, oh, we haven't talked to those people in years. Or they had kids and we saw how they parented, and now we got to do something
we got to
else.
get out of this.
Like, bad choice.
Yeah. So yeah, people, their capacity changes, your relationship with it changes, you know, what's going on with them financially changes, where it might affect who you want. And the other thing is, after about 5 years, people forget what their documents say.
Absolutely.
Yeah.
You know?
I was going to say, is there a rule of thumb, a guide? So like, you know, obviously if there's a major life change, like marriage or divorce or something like that, or death in the family perhaps, but every 5 years or so, is it a good idea to revisit?
Yep, I send a letter to my clients 5 years after we do a document, not because they expire, but because it's just a good time to, I say, blow the dust off and see what they say and make sure all those people are great. And once in a while, you know, I tell people, you're really blessed if you come in 15 years later and all the people are the same and they're all alive and they're all married. Good for you.
Yeah.
We can talk about some of the documents maybe need to be updated with legal language, but we don't have to make huge structural changes. But the norm is that we have to do a couple of things.
You'll do a free consult with people about this.
Absolutely. And I'll do a free consult whether they've done work with me in the past or not. Just bring in whatever your estate plan is.
Yeah.
And we'll talk about, here are the pros and cons of doing something different, and here's how much it costs, and you can decide whether it's worth it.
Love it, Al. Good to see you.
That.
Yeah,
it's important
nice
to
to you
just
as well.
get her done.
Yeah, there you go. Avoid
Thank
those
you.
5 mistakes and call the McLario firm. That's how you can set up your free consultation in matters of estate planning. Their number is 262-251-4210, or for more information on any of their legal services, you can visit McLario.com.